These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Brandon, you want to talk a little bit about public and private commerce?
Okay, these are actually terms a judge gave me. Okay? This is very significant. This is a judge who evidently came about our materials and attended my last Living Temple session in April. And he illuminated us in the what he calls private commerce and public commerce of court. Okay? Basically, private commerce is where we have, you've heard Jack talk about form and substance. Private commerce is where they recognize substance. Public commerce, we have form. Where, in relation to these two, do you think your filings with the clerk belong? Public commerce. So, filings with clerk.
Because the clerk is part of the public side, the court.
So where does what side is your private administrative process on? Private. So we'll put our administrative process on the private side of commerce.
That's where it belongs, but can we accidentally put it in here over here?
Oh, many people have accidentally put it over there. So, the distinctions that he made for us. Oh, well, let's go with a few more distinctions here of what belongs in private, what belongs in public. Where's the courtroom? Public. Okay. So over here we have the courtroom. Where is judge's chambers? Okay, so the judge's chambers is in private commerce.
Or also referred to as in camera. In camera. In camera, like a photo camera thing. So in camera is also what's termed the judge's chambers. In fact, the whole courtroom can become the judge's chambers on a few kind of interesting points. We've had, not only myself, but numerous students have entered into a courtroom, stood out in the gallery. The clerk announces the case or announces court coming into session. You've all come into a court, you're sitting there, where a clerk will say, "All rise." I've been in numerous settings where the clerk says, "Everyone remain seated." And those standing take a seat, and out comes the judge. Did the whole courtroom just become the judge's chambers? Yes.
Well, hold on. What the judge told me was that if the judge is wearing his robe, we're in public commerce. So even if we're in the courtroom, if he does not have his robe on, we're in private. So private commerce is judge without robe in courtroom.
Now, an interesting one, maybe you can enlighten us, Jack. I've seen the judges, and he just says, "Come right on in." They said, "Stay seated. I'm here today as the authorized representative for the surety over the defendant, hereinafter defendant, merely for the purpose of set-off settlement and closure of this matter. If it please the court may enter the bar under said terms." Just come on in, that's fine. Let the record show I'm under said terms and conditions and walk in. Are we private or public?
So, how many are familiar? I'm not sure if I did this in between sessions or in the session. Did we talk about rules of evidence? Yeah. And the exception to the hearsay rule and the notary record and everything? Okay. So, basically, if we're bringing our administrative process into the court, we know we want to bring it into private commerce because that's where they'll recognize substance. So if we're submitting our administrative record through the notary under seal, it will go directly to judge's chambers. I'm not bringing it to the clerk and filing it at the court.
Brandon, what do you mean by you're bringing the notary record under seal?
If I want to bring a record of my administrative process and I want it to qualify as an exception to the hearsay rule, in order for it to qualify as an exception to the hearsay rule, it must be a third party's authentic, genuine, original record. Okay? And the third party is the notary. So if it's the notary's record, who's submitting it to the judge? The notary public.
A quick question, Brandon. Now, when I'm doing my administrative process on the private side out here, and I'm using a notary public, when I send my first step, unless it's like a monetary instrument, but if I'm doing a second and a third step and I'm using non-responses, etc., am I only going to send the other party copies so that I keep the originals so that I can make them part of that record that goes in to see the judge? And is that important that I have original certificates of service, cards, those types of things?
In fact, a certificate of service is an affidavit by the notary that a specific set of documents were presented, right? And the notary is testifying that the records were mailed under a certain mailing number, right, or tracking number. And they're literally testifying that I deposited the envelope with the United States Postal Service, right? So would there be a signed copy of the certificate of service in your presentment to the other party? How can that be? How can they testify that they dropped it in the mail if it's in the envelope? So if you've ever seen my certificates of service, there's the last line on the certificate of service of the documents included will be the certificate of service itself listed as one of the items. But it'll have in parentheses, signed original on file. Because I'm sending a certificate of service that is not signed by the notary. Because how can the notary testify that they deposited it with the United States Postal Service if it hasn't been done yet?
Well, they put that in. Can't they just sign it and then put it into the
Yeah,
post
but how
office?
can they testify that they already did it? Right? Okay, so take that into consideration. Do you want your notary to be committing perjury? No. So keep that in mind, that when your certificate of service that goes to the opposing party is just a blank one. In fact, how many have ever received a court process with a proof of service that didn't have any signature on it? Yeah, because how could the person who served it testify that they served it before they served it? So you'll get a proof of service, but it's not signed. Where's the signed one? They filed it at the court with the clerk. Okay? So original certificates of service and original certificates of non-response are part of your record. Now, if your notary is in one state and the court process that you're doing is in another state, I recommend that you get that certificate of service and any certificates of non-response or any other certificates of your process or affidavits by the notary where the notary's signature and seal appears on the document and you have the original. Get them certified by the Secretary of State. What's significant about a certification by the Secretary of State of the notary's signature and seal?
Does that make them usable from one country to another?
It does. It not only does it make it usable, it makes it what? Self-authenticating. What else? Substance. Legal. Legally recognized internationally.
Are you saying California and Arizona are countries, so that makes
There's
them
two
recognizable
different nations.
international?
California Republic and the Arizona Republic are two distinct nations.
So we got 50 distinct nations in these united several states.
Exactly.
I just wanted to clarify on that certification, the certificate of service, rather. What we've done in the past or what we've been doing, is sending in copies of the certificate of service with the notary retaining the original. And if that's not correct, I want to correct that.
How can they testify, again, to something that hasn't been done yet? Really, a notary can't sign the certificate of service till the envelope's already been deposited with the United States Postal Service.
So in correcting that, then basically with that certificate of service, we could put, as you suggested, original on file.
Yes, original
So something
on
else
file.
you could do here, Brandon, if you couldn't reach your notary and you typed it up and you had it right and you knew your notary real well, you could actually go drop it in the mail and the notary drop by a couple days later and sign that, huh? Sign the original. I mean, you technically could do that and get away with it, right?
Well, you can technically do a lot of things and get away with it, but I like to stay above board on all my processes, meaning I'm honorable. I'm not going to, I've even had notaries offer to me, oh, well, you just go and you do that. I'm, oh, no. That's not going to happen with me. You may do that with your other clients, but with me, you're going to go by the process and you're going to do it correctly. You're going to keep a record, because I actually had a notary because I always bring copies of everything that's being presented, because the notary is supposed to keep a record of what was presented so that they can testify that, yep, that's what I presented, because here's my record of what I presented. And I had one notary tell me, oh, I don't keep copies. I'm like, really? Well, you're not going to be my notary. Because if you don't have a copy of the record, how can you testify to what I presented? Oh, well, I'll just say I did. That doesn't help me any. Now, do I want a dishonorable notary? No. Do I want a notary who's willing and able to, or willing to commit perjury? No. We want to keep our process tight.
Isn't it the difference between substance and form? Because the notary is saying, I'm testifying to this, but in substance, we're not going to do that. We don't care about substance. We're just going to go through the motions. Well, look, what are we doing? Are we trying to substantiate substance as part of our republic for set-off and settlement? Or are we just going to go through the form and it don't make no difference? You just disqualified your whole procedure.
Now, whether or not someone calls you on it shouldn't be what you use to determine how you do your process. So yeah, will you ever be questioned on it? Probably not. But I would say it's probably a good practice to stay above board with all your processes. Be honorable in all your processes. Don't have your notary committing perjury on the documents, because it's likely that if it were ever questioned, that your entire process can fall apart. So let's... Say that again?
What Secretary of State do you have signed the...
It's going to be the Secretary of State
The apostille.
that gave the credentials to the notary you used. Because he knows who his notaries are.
Okay.
See, the notary is doing his function as to his relationship with the document. The reason you're going to the Secretary of State is because the Secretary of State has no interest in what's on that document on substance, other than the fact is that my notary that signed that. So the Secretary of State is verifying the seal and signature of the notary. That's it. But you see, in some other state, they don't have the records as to whether this guy is an actual notary in Georgia or whether he is an imposter. So in reality, the Secretary of State that appointed that notary has the records. What does his seal look like? What does his signature look like? So the Secretary of State is verifying the authenticity of the seal and the signature of that notary. The rest of the information on the document is outside what the Secretary of State's dealing with.
Does anyone know how we bring a judgment from a foreign court or a judgment from a higher court into another court? Anyone ever heard of a letter rogatory? A letter rogatory? Okay. What did we say our notary? Our notary was a witness and served as creating a court, correct? And we called it a higher court than any public court that we're dealing in, right? So if the notary is our court, the higher court, and the notary witnessed our process, that witnessing of the process, when you include all the documentation of the process from presentment documents, the documents presented, the certificates of service, the certificates of non-response, any second and third steps if you had a notice of fault, a notice of default, all of these documents with all of their certificates are together a judicial determination. So if we already have a judicial determination and we're bringing it into private commerce, what capacity are we invoking in the judge? Administrative or judicial? Administrative. We already have a judicial determination. right?
Res judicata, once decided, always decided.
Res judicata.
Against the world.
So, you have a question?
Basically, going back to what Jack said about the Secretary of State was supposed to just recognize that the notary was in good standing and get a apostille.
Right.
In the state I'm from, that didn't work.
No, you're talking apostille. He's talking certified.
An apostille is if you're going to take... See, the thing
International.
about... Well, remember, it's still international from California Republic to Arizona.
Right.
However, the states of the Union, the 50 states, have a special relationship. We've formed a society we call the United States of America. And within the United States of America, we don't need apostilles from California to Arizona. We get what are called notary or Secretary of State certifications. So if you're taking it to The Hague, you get an apostille.
Yeah, that's what we're doing. He was taking it to The Hague to get apostille, and
Whoa.
He took-
Getting an apostille to take it to The Hague, you mean?
yeah,
And where do you
Because
get
The
this
Hague
apostille?
can't apostille something unless it's from the Netherlands or something. Where's The Hague? Is it Denmark or... Is it Denmark? I think it's the Netherlands for some reason.
I did the notary for him. He took it to get the apostille, and went. He was told the way to do it. He went to do it, and they basically told him the documents were not fraudulent or whatever, so they wouldn't give him.
You were probably trying to apostille something that wasn't proper in form to be apostilled. What are you doing when you're getting an apostille? Exactly. All you're doing is authenticating the notary's signature and seal. If you brought in one of your documents to get apostilled, can the Secretary of State apostille it? No. They don't know who you are. How can they authenticate your signature?
Anyway, I lost my notary because of that.
You lost your notary?
Yeah, they took it away. I mean,
I think-
I rebutted it. You know, I was just
I think
notarizing
Gordon's
the
got
document.
him. He's putting notaries away in his closet.
Anyway, so they took my notary away because of that.
Because what'd you try to do?
I was just notarizing the document for him.
Notarizing a signature or notarizing a document?
His signature. I notarized his signature.
And he took it to go get an apostille, purportedly.
It was an administrative review process, an 8-letter process that he was doing.
And you did nothing more than simply notarize a signature.
Correct.
Well, then all he needed to do was get a certification from the Secretary of State on your signature and seal. I'm telling you this
reason?
because a lot of people think an apostille is something other than what it is. So they try to get documents apostilled that have no business being apostilled. They think it's going to give it some kind of crazy significance, and it doesn't. All we're doing is authenticating the notary's signature and seal.
You know what it may have been is they should have certified it in the state. And then if it did need to be apostilled, it would go to the Secretary of State, U.S. But then when it goes there, they're going to say, well, what country and nation are you sending it to? But to go directly from your signature to an apostille, instead of through the certification by the Secretary of State there, they were probably jumping over a process. It wasn't the valid way of doing it.
If you're going to go international outside the borders of the several union states, then Washington City issues this great big old seal. It's like $142 last time I heard. And there's your apostille.
See, an
Authenticating
apostille-
your Secretary of State.
An apostille is internationally what a certification of your Secretary of State is domestically. Because when it goes up to the Secretary of State, U.S., you don't think that all of your Secretary of States in the several 50 states aren't registered with the Secretary of State in Washington, D.C.?
Washington City, actually.
Yeah.
And some states do not have a Secretary of State, but they have another individual serving that role. I believe Utah doesn't have one. Alaska, I don't think, has one. It's the lieutenant governor that serves that role. Okay, and in your state may be the same. You have to look into your state and see who are the notaries of your state and agent. That's who you're going to find that does apostilles for that state. Now, let me take a step backwards because we were talking about the letter rogatory, right? Okay. When I want my notary to present their record in private commerce, I draft a cover letter that's going to go on top of the record that's going to be submitted into judges' chambers. That cover letter I entitle Presentment of Evidence Under Seal. And it's from the notary to the judge. And the language, remember, it's about substance. So you may get a copy of this form that I use, but it's not like the form I use is the form you must use. It's the substance of the form that's important. So you don't even have to use the same title I use, but I like to make a clear distinction for the judge. This is what's going on. The title alone should make the judge aware of, presentment of evidence under seal. That should give him an idea of what is behind that cover letter.
Are you sending that, each step of that to the judge? Are you culminating all in one?
I take the complete record. Now, if this is an expedited process of some kind, I may send in each step individually, but each step will have that same cover letter on it. And it may be different, because I may be illustrating in the cover letter that this is a process that has been begun. It is not yet complete, but you hold on to this until I get you the rest of them. So, and remember, the notary is just the witness. So the wording of your presentment of evidence under seal document should be something like, Dear Honorable so-and-so, I have been contacted by Brandon Alexander Adams, hereinafter principal, from outside the United States for the purpose of presenting the following documents under seal. And then maybe list out all the documents. Next paragraph. The principal has asked me to mention. See, because we don't want the notary to start making demands of the judge, right? The notary is just a witness, just making presentment of her record.
Bring to your attention, mention.
Right. So the principal has asked me to mention that these documents are evidence of a private administrative process whereby an agreement of the parties was established. The principal has asked me to mention that because these documents are private and proprietary, and any public distribution of these documents would prejudice his rights, interests, and titles, that these documents be kept under seal. The principal has asked me to mention that because these are genuine, authentic, original records, that the judge keep them safe and return them upon the conclusion of this matter, and return these documents to the principal through me, the notary, at the following address. Because you probably want to get your originals back at the end of the matter, right? Then I may go on to the last paragraph saying, the principal has asked me to mention that pursuant to the agreement of the parties, because depending on the nature of my process, usually the default, if I'm doing a process and the process I already had knowledge of a court case, I would probably put either in my notice of fault or my notice of default that upon their failure to rebut the presumptions of my affidavits or whatever else, that they're agreeing that this matter should be dismissed with prejudice. So in my cover letter, the principal has asked me to mention that pursuant to the agreement of the parties, that this matter be dismissed with prejudice. See, a letter rogatory comes into a lower court, basically instructing the court, this is what you're to do. So I've basically put it to the judge that, you're going to dismiss this matter with prejudice because of the
That's
record, the agreement of the parties. Now, interesting little story. I had a process, and this was when I first began, so this was quite a harsh process. This was before I was all about going to peace. But this process was dangerous. Like, in that I was very much about charging my brother. This was like highly volatile process. Like, you impede or prejudice my rights in any way, and this document's going to explode and take your entire law firm with it. Okay? That's basically the nature of the process. And I had established the entire record and everything, and I had put it in, and this was a court case where there were a couple of, we had a corporation, and we were doing business as this corporation. It was originally our corporation. And when I say our, it was me and a couple of my friends and my brother. We were all running this corporation. We got into a contract to do what we thought was going to be some big business nationwide. And so we brought in a CEO because I didn't feel qualified to be doing the type of business that we were doing as the CEO. So we brought in someone who was very experienced at being a CEO of large companies that deal in very expansive contracts, okay? And so we bring in this CEO, and he ends up embezzling money, the investors' money, out of the company. Now, the investors, either not being aware of indemnity of the officers of a corporation, or being aware and just ignoring the indemnity of officers of a corporation, decide to go after us individually and the corporation. Now, as soon as we all got our summons and complaints, they wanted $666,000, interestingly enough. Does this tell you what kind of people we're dealing with? So they were coming after us for $666,000. They were going after our corporation, my brother, myself, and two of my friends, and the CEO. Well, I didn't care if they went after the CEO. I wasn't going to protect him on this one. However, I had my friend, my brother, and the corporation give me the paramount security interest in all their properties so that I, as the paramount security interest holder, could do a process on behalf of all those parties. Okay? So I did my process through the attorney, private administrative process. Okay? Basically, remember, I still was about settling. So it wasn't that I was arguing the facts. I said, oh, you want $666,000? Well, here's a bonded promissory note for $5 million. I'm very, very considerate and compassionate towards their plight. So I was going to pay them almost 10 times what they were asking for. Okay? What do you think they did? You think they responded? Nope. You think they rebutted anything? Nope. I then took my record of this process. I got every document that had a notary signature and seal on it. I got apostilled. I took those originals with my record.
Apostilled or certified?
I got them certified. I'm sorry. Because it wasn't leaving the United States. So I got them certified by the Secretary of State. I took that entire record. I put on top of it a cover letter that said presentment of evidence under seal. Had my notary make presentment to judges' chambers. Directly addressed to the judge. The envelope had private and confidential and all kinds of things stamped on it. Registered mail. I never showed up to one hearing. Neither did my brother, the corporation, or one of my friends. My other friend got scared. He was like, you're insane. I'm going to go get an attorney. So he decided to blow his money on an attorney. My brother has nothing but faith in everything I do. So he was very much on board with, I trust you, Brandon. You go ahead, you go big. My other friend, not that he trusts me, but he wasn't going to go spend the money on an attorney. So it was more like, we'll see how you do. And if it gets too scary, maybe I'll get an attorney. So he had a little bit of faith. So none of us, the corporation, myself, my brother, my friend, we had no attorneys. We never appeared once in court. The opposing side tried to get summary judgment 5 times.
Now hold up, I got a question.
Okay.
Did you ask to have the proceeding abated while you did your administrative
I did
process?
nothing on the public side.
So
I never filed one document on the public side of this case.
Hold on, you got a summons to the lawsuit?
I got a summons and a complaint.
Then did you start your administrative process?
Yes.
And how long did it take it to do it?
20 days. What's that? After the first default. After the first default of what?
Of their process. We defaulted and didn't even respond publicly.
Okay.
Well, you get a lawsuit.
I think what you're saying is not what he...
I'm not saying what
Okay, yeah, I was going to say, I think he's asking something
Let me
else.
get this right so we all can know.
Okay.
You get sued for $666,000.
Yep.
You don't answer the suit or anything. You immediately get busy and you start an
I
administrative
start-
process.
right.
And you send them a $5 million bond to set off, settle, and close the matter.
Right.
When they didn't ledger the funds or whatever, dropped the suit, after 10 days you sent a second notice of fault opportunity cure. 10 days later, when you didn't get that, you did your final record, and you immediately got that into the court. So you were roughly about 20, 21, 22 days when it finally hit the judge's chambers.
Not only that, I filed several public records. Like I filed UCC 1s, where I listed in the collateral not only the property of all the registered and unregistered property of the debtors, but the case itself. Because I had just put $5 million in on this account. So I got a $5 million interest in this account. And I included that in the record that I sent to the judge.
Did the court know that you had done any of that yet?
No. They didn't know anything.
So you're just doing all this over here on the private side?
I was doing it all on the private side.
And then you pulled out certified copies of the UCCs and all
Yep.
of this, that, and you then put it all together and you got certification on each of the notary's presentments and non-responses, and you took that entire record at about 22-day or 23-day, put your letter rogatory on top, sent it into the envelope only to the judge.
Only to the judge.
So you didn't provide a copy to the opposing counsel,
Nope.
to the court,
Nope.
to anybody.
Nope.
Just to the judge.
Just to the judge.
Okay?
Okay? Then, like I said, they tried to get summary judgment 5 times. Never showed up to one hearing, never filed one thing on the public side.
How do you know they tried to get summary judgment?
I watched it on the docket.
Okay, so you watched the docket sheet. No, that's okay.
I logged in and I watched on the docket to see what was going on.
Did the opposing counsel send you notices of these things?
Oh, yeah, they sent me all kinds of stuff.
And
They
you
kept
just ignored all that?
Just ignored all of it, just said, I'm going to see what happens.
Well, isn't that kind of like a dishonor?
No, because they're just sending me notice of what they're trying to do on the public side. I've already handled it on the private side.
But isn't there just 4 doors to go through on every presentment? And then
They were never asking me for anything. They were just giving me notice of what they were doing.
So didn't you tacitly acquiesce to have a judgment against you or summary judgment and you ignored it?
No, they never sent me anything about the summary judgment. We saw that on the docket. They were moving for the summary judgment in the court.
So if they would have sent you a movement of the summary judgment in the court, would you have responded to that? Like on proof of claim that your private record hasn't settled this matter and blah, blah, blah?
Perhaps, but not necessarily.
Okay.
Because if it's not directly addressing me, if they're just saying, we're going into court, we're motioning the court for a summary judgment, I go, okay, well, that has nothing to do with me. They're not asking me to be there. They're not asking me to rebut anything. So they're just giving me notice of what they're doing on the public side.
But in your private process, the $5 million, did that go to the court? Did that go to them?
It went directly to them.
So they knew your private process was finished.
Exactly.
And so they did not in any way, shape, and form ever rebut that private process in the public.
Nope.
They had noticed that they had the tender and they were under the certificates.
Yep.
Did they ever respond to your first or second notice in any way?
Nope.
They just tacitly acquiesced In other words, they said nothing about the entire thing for the 22
Now,
days.
because one of our friends was also an investor and he was directly communicating with these guys,
Yes.
he would give us information about what was going on.
Okay.
Insider trading.
Insider information. And he was telling us that like when the attorneys got our presentments and stuff, they were all laughing how ridiculous it was. And they were making fun of me that, oh yeah, Brandon thinks this is going to have some effect. What an idiot.
The judge saw both sides.
The judge saw both sides.
They had been tendered the $5 million. They
Yes.
knew about it. They got the certificate when they did not rebut it.
Right.
The judge knew about that.
Yep.
You had your private package before the judge. Did you inform the attorneys on the public side? You put that private packet
Nope.
in front of the judge.
Nope.
So only the judge had that notice.
Only the judge had knowledge of my process was before him.
But they never put in any process charging you in public. They just went into the court and asked the judge to give them something.
Right.
Because the attorneys are under canons of ethics. And the attorneys, knowing that there was tender, and therefore under the certificate discharge, they could not bring any charges against you. Otherwise, it would be fraud in violation of the canons of ethics.
Absolutely.
So their petitions for summary judgment in front of the judge was merely summary procedures on the public side. And if they were entitled to any bifurcated relief, the judge could have granted it to them. But the judge had evidence that bifurcated relief was not coming to them, so he denied anything on the public side.
What do you mean bifurcated?
That's for me and Brandon to know. And
Well,
you
some
to-
of us need to know what you mean by splitting it. I mean, what is bifurcated?
That's a very important word that you need to look up. Because bifurcated means there is a public component to something and a private component to something.
We talk about bifurcated marriages, remember?
That's
And
correct.
So tell them about that.
I
now.
had a friend that was married, and at the time that he and his wife were married, they decided that they were going to go down and they were going to file UCC notice of security interest. And during the time that the wife and the husband were getting along, the wife signed over to the husband a security interest, which takes the modern marriage back to the biblical covenant, which means that the husband will be responsible for his wife's debts because she turned over to her husband a security interest, which means when she turned over the security interest in her public straw man trust for the private trust of her husband to supervise.
Because he's managing his private trust is
And
managing the
hers.
public trust of his, and his private trust is managing now her public trust.
Yes. Now,
Okay,
see,
got
under
it.
the biblical covenant, it is that the woman is immune from commercial liability
Because the man's responsible for everything?
for all of his wife's debts.
And in fact, even in the United States, that was the case up until women's suffrage.
See, the woman came in and she said, I want equal rights. You know, there are no rights, there's just duties and obligation.
So we'll
if
give you
want
equal
rights,
obligation
you
and
get
duties.
Okay? So when they
So
passed the woman's rights, she now could go to prison for her debts.
Whereas
there was
before,
hardly
she
no
couldn't.
women in jail before, was
Yeah,
there?
there was no women
No
couldn't
women
go
in
to
jail.
jail for debts.
So the rights they got was the liability to pay their debts, and now we could throw women in prison. Whereas before that, remember in Scripture, doesn't it say that Jesus is the husband and the church is the bride?
Yes.
So the church is the bride, and who pays the debts in the marriage?
Well, the husband.
The husband. So the church had a debt of sin, but the husband's taken care of that now that we're married. Because there are no equal rights. All right? So under equal rights, his wife was liable. And so she goes, that's okay, honey. You can just be responsible for the debt so I don't have to go to debtor's prison. So I'll sign this security agreement and you control all the property. Now, under trust, if you're in control of the property, do you have legal title?
Yes, you do.
Okay, so she had equity, he had legal. Then she decides, I'm going to run away with this guy, and now I'm going to get a divorce. So she gets her attorney to file a divorce action in a family public court. And my friend comes back, he served the documents, and my friend comes back with a conditional acceptance that's like, you guys are doing what? Where the heck is your authority? Look at who I am. I'm the secured party creditor. Did I give you any authority to issue some kind of public process dealing with my property?
Which was her public trust.
There you go.
So he had the UCC put in there, or it's public record. They should have known,
And he
right?
basically said, what the heck are you guys doing? You going to trespass on my contract?
So he said this is the response back to the divorce offer, right?
Mm-hmm.
Oh, okay.
So the woman attorney for the wife goes into court. He has not responded to our summons and has not put in an answer. And she goes to the judge, I want contempt order against this guy to compel him to come in and divulge all of the property and help with the settlement on this divorce. And the judge goes, no, I don't think I'm going to issue that order. And she goes, why not? I just don't think I'm going to issue that order. You can try something else. And this went on for a year and a year, and finally a woman attorney said, I want you to do this, and you got to pay me for your wife's fees. And he goes, well, when did I have a contract for you to work for me? Dealing with my property. But I'm representing your wife. And how does that trump my security agreement and notice of security interest?
It doesn't trump it, but as the fiduciary and the trustee in control of the collateral of the wife, it is his duty to discharge her debts.
Unless she hasn't been contracted for any purpose by me with proper authority to do this. So she kept going back, and finally she put in a motion for a bifurcated divorce. Now, luckily there were no children involved, so it was just property, okay? And all the property was on the security agreement, so basically he was in control. And so she puts in a motion for a bifurcated divorce. He goes, bifurcated divorce? Bifurcated divorce?
Now, he wasn't granting her a divorce before this?
No.
Okay. Because he was the trustee, the private trustee over the woman, and it's a woman corporation we're dealing with.
Biblical,
Okay,
what are the reasons for divorce? Well, he may have been able to generate one, but I mean, it was like...
There is no divorce.
Unless I say so here,
yeah,
or
women
whatever.
love that.
And so she put in this motion for bifurcated divorce, and he gave notice to the court not to trespass on any of his recorded interests. So what came out of the court decision was the judge said that the wife is hereby granted a divorce and is no longer married in the eyes of the state to her husband. With regard to any property issues, this court does not issue any judgment, order, and decree. And then that was it. What did they just do? What is a marriage in the eyes of the state? Joinder of Corporation A to Corporation B. Has nothing to do with the scriptural concept of a man and a woman getting together.
So public trust Gordon Hall with public trust Mary Hall.
Public trust husband, public trust wife are no longer in the eyes of the state looked at as being a joint venture. Amen. Goodbye. Did the state have the authority to undo what the state gave authority to do?
Yes.
Of course.
Yes. As regard to the separation of property, whoa, we don't have any authority to go there.
Because of the UCC and
He's
the
got a
agreement of the parties.
security interest. It's on the private side.
This would be kind of like when the warden went into the federal district court and attempted to get the lien off him, and the federal district court says, we have no authority over the commercial code of the state.
Mm-hmm. Because they're operating under the commercial code of the state, and if they ruled against it, they just dissolved their court. Their court is a commercial venture to collect debt. It's a debt collection company.
Can that be done with your children?
Well, now the children are the product joint venture of the marriage, which is just the union of two corporations. So next question is, what was the security interest between the two corporate entities that decided the fate of the collateral of the children, and was it registered and recorded in the security agreements also? Because, see, under the common law, the husband is entitled to the children because they are his posterity. But under international law, if a husband marries an alien wife, the wife under international law is entitled to the children because the proceeds of a union which involves domestic and alien could end up jeopardizing the title of property under the common law in our republic. If you married a foreign woman, you died and her children became the heir, but then moved back to the situs of the mother, thereby bringing foreigners onto our land and picking up our title. But that's under the common law, and that's kind of irrelevant to the modern structure of things as they want you to appear today. But it's all under the contract and the agreements. The children can be incorporated.
So we're right back at consent makes the law or makes the contract?
I'll buy that.
My question is, you said with him filing the UCC-1 and putting her on the security agreement, that it was private. How does that become?
The UCC-1 is a public filing.
And it's the
of
notice.
A notice.
The security agreement is private.
Of a security agreement. The security agreement is private, and if you attach the security agreement to the filing and recording, you just undone the private nature.
Do not file your private papers on a UCC form. Do
You
not
just-
attach it. Make reference to
make
it.
reference.
Keep your documents private and say something. If for further information, contact the secured party creditor at so-and-so number, what have you.
Brandon, you said you gave them a $5 million promissory note?
Yeah.
And that was on the private side, and he's got the agreement on the private side. So this whole issue of bifurcation came up, talking with Brandon's issue. See, Brandon never appeared on the public side. So what could they go after in public to affect Brandon in private? Well, the judge had noticed that the public's debt got discharged with Brandon's private tender, and they defaulted to that. So the judges go, you guys got paid. Why the hell are you still here?
Okay. But did they ever collect on it? And if they didn't, that's one thing. But how would you collect on it?
He'd give them,
Collect
if
on
they
what?
came to redeem the promissory note, he'd give them 3 more promissory notes.
No. My promissory note was on my.
Asset account.
I have bonds deposited with the Treasury.
So how would they go
That
back
bonded
to
promissory note was secured by the bonds on deposit with the Treasury. So if they're going to monetize it, I have nothing to do with the monetization of that note.
How would they do that? That's my question.
I don't care how they do it. I have no interest in how they monetize their instruments. So it's up to them. That's up to them.
Did they probably collect on it? No.
Well,
I mean, if they didn't have enough knowledge to realize that they had just gotten paid and they were going to move forward with the case thinking they didn't get paid,
right,
they probably don't know how to monetize the instrument.
Okay. But along that
Otherwise, they'd have just dismissed the case and go, yoo-hoo, we just made $5 million. Right?
Along that same line, you mentioned one time before, I think in the March seminar, talking about y'all were working with some groups to organize your own banks.
Yes.
Is that proceeding on? Can you elaborate on that any?
Not right now, but yes, that's moving forward. Now, keep in mind that This went on for 2 years, this case. And the judge the entire time had knowledge of my private process. For 2 years. Now, I was tempted on several occasions to go appear in court because I got a little scared about what had appeared on the docket. But I never did. In the end, after 2 years, the judge dismissed it with prejudice.
Did you have that request to dismiss and prejudice within your private agreement?
No, I didn't. But I would add that now.
Yes.
But I didn't have it in. Really, the judge was protecting them because he saw the volatile nature of my process. If he'd have given them their judgment, I told you, the whole law firm would have blown up. Oh, okay, hold on. Not literally, okay?
No terrorism
Not
here.
literally. I mean that the law firm, the attorneys, the principals behind the lawsuit, all of their assets were attached to my counterclaim. And my counterclaim was like 10 times what the amount of the note was. So I would have been able to liquidate the law firm and every attorney at that law firm's property, the plaintiffs in the matter. I would have been able to liquidate all their assets on my claim.
Now understand what Brandon is telling you here. He's basically saying, I've given you a certificate which shows the $5 million tender is good. But if for some reason you people totally ignore what I just gave them, $5 million, I'm coming back against the people that have already got my $5 million that didn't apply it to this case, and they're going to damage me somewhere else, and I'm going to recover my $5 million, which I've already given them. So is he charging his brother for money that he's trying to get out of his brother because he doesn't like him? Or is he just saying, but if they ignore what I gave them, which is more than enough to set off, I'm coming back to get it again from them? So what Brandon is really saying is, I've been subrogated now on this claim, but if they don't take my payment, I'm gonna bring in a process to redeem my subrogated interest in the amount that I've subrogated that debt.
What do you mean subrogated, Jack?
You owe Brandon $1 million.
Okay.
I step in and say, Brandon, it's going to take forever to get a penny out of this deadbeat. But I like him kind of. And he's in a venture with me, and I don't want you to mess with him. Here is his $1 million that he owes you. Would you write me out a receipt? You give me a receipt. Now I am in the position of subrogated to Brandon's interest. His interest is a claim for $1 million. I just bought his claim. If this gentleman doesn't someday pay me the $1 million like he owed Brandon, my subrogated interest can go into court and sue him as though I was Brandon to get that $1 million. So I've got a right of claim by subrogation.
So
Brandon paid the debts of his brother, the corporation, and everybody else, and he paid the other creditor. The other creditor went, oh, damn, we got paid. We should just dismiss the case and go. But they stayed in the suit. And Brandon is going to the judge, look, they've been paid. I'm telling you, they have agreed they've been paid. And we paid them $5 million. Here's the way it's going to go. If they don't stop this case, and they've got my $5 million, I'm given notice that I'm coming back and suing these people for the amount of my subrogation, $5 million. Are you threatening anybody with any claim that you don't have under law?
Nope.
He already transferred $5 million to them. He's just saying, if these people ignore the payment and screw me, I'm going to come after them for the $5 million.
Wait.
And the judge goes, that's not a problem.
Right, but the judge, in his infinite wisdom, realized that his primary duty is to protect the public. So
and they're the public.
Right, and they're the public. So rather than issue a judgment against my collateral and thereby create some kind of like a $50 million liability on the public, he said, I'm just going to dismiss this with prejudice, because by dismissing it with prejudice, that's equivalent to what I was asking for, the discharge of the account.
Let me get this right, Brandon. So you, Brandon, private trustee, came in and put $5 million in for Brandon Adams, public trustee,
And
Garrett
other
Adams,
public
trustee, and a couple of friends. And that's what the private process, and that's what the judge saw. So you subrogated the debt and therefore became the creditor in the matter.
Exactly.
Okay, that's a little more clear to me.
And it wasn't an open threat
No.
that he didn't have a right for. Because under the law, once he paid the corporate debt and the public debt, he could go back and make a claim against these other people that didn't understand the law.
And it was incumbent on the judge to take recognition, or matter of fact,
Yes.
you're going to go a little bit further and tell us about
actually,
that, aren't you?
that's the other thing I wanted to mention is that
What's the time is it?
what this judge told me that attended our class last week was that everything in private commerce does not belong in the record. Record of the case is on the public side. There is no record of private commerce in the court. However, it is the judge's duty to take everything that happens in private commerce into his knowledge so that when he transcends the barrier between private and public commerce and enters public commerce, he has the knowledge of what happened in private commerce and renders his decisions based on his knowledge of what happened in private commerce.
But everything, Brandon, in private commerce, this is why you're saying we have to be very careful how we do it using the proper notary certificates of non-response, certificates of service, and make sure that record via letter rogatory gets sent into the judge so that it might have happened in private, but unless he has cognizance of it, he has knowledge of it in proper form, he's not going to take notice of it, is he? Like if we just didn't have any certificates of service, we didn't have a non-response, we didn't have a third-party witness.
Or if you just sent copies.
Or if we sent non-originals.
Right.
Now, I could send original non-responsive certificates of service. Do I need to send the original contract?
No, because the original contract, they're holding in their hands.
Who is?
The opposing party. I sent the, remember, the original contract was my affidavits, conditional acceptances, the note. If I kept the original notes and everything, I'm the trustee on that process.
No, but I can understand.
So I made presentment of those documents to the other party. I had the original certificates of service, original certificates of non-response, and all those documents.
Those are the equivalent of receipts.
Exactly.
They had the payments in original because without the original payment, they can't process and get their funds.
Exactly.
Okay.
So
does the concept of star chamber proceedings come to anyone's mind? All these new words. Oh my goodness, star chamber proceedings. What is a star chamber proceeding? It is a court action in which the judge has all of the evidence in chambers and not in the public record and makes a decision and final determination. Don't patriots hate star chamber proceedings? Because your immediate assumption, remember that comfortable box that you sit in, is that the courts ought to be open for inspection and everyone ought to be able to see all the evidence so that the judges cannot engage in fraud and secrecy. But what are we asking the courts to do? We don't want fraud. We want to conceal our record because to expose it to the public creates a prejudice against our record. And we can't get a remedy because we're going to the private side to get funding, and the military democracy doesn't want to recognize there is no accounts there. There is no money in Treasury. You can't do that. So if we don't keep our record of evidence private, the judge has got to deny that those facts exist, thereby preventing us from having evidence to show set-off, settlement, and closure. So we want star chamber proceedings, not because it generates fraud, but because we can get a remedy operating in private, whereas ordinarily the public only deals in the public. Go ahead.
Coming on.
You got
Okay,
you.
there it is. There it is. Okay, pertaining to the same thing with the $5 million note that you gave him, you made a statement that you put it on the UCC1. So on that UCC
Notice of it.
Notice of it. So notice of it. So you didn't actually, when you filed the UCC1, you put yourself as the secured party, them as the debtor, and
No.
the attorney.
No.
The debtors were Garrett Adams, Brandon Adams, my friend, and a corporation.
Because they're the ones whose debt he paid. You
Okay.
don't put the creditors down. You just paid the money to the attorneys. They were the creditors in the claim. You put it down to the people that you paid the bill for, which was your public trust.
So there
Okay,
were-
so the creditors is going to be the attorney, and the debtors is
No,
going
no,
No.
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 It's my security interest. Who's the creditor?
The
You.
private
Right.
trust, Brandon
Okay.
is the creditor. The public trust, Brandon is the debtor.
Subrogation again. Remember, he paid the straw people and the corporation debt, so they're the debtors, not the attorneys.
See, that's why people go to prison, because you put down yourself as the creditor and you put down those attorneys or public officials as the debtors. You paid their bill. They were a creditor. You're subrogating the interest of the other debtor.
Now,
Okay.
in the agreement, the contract I had with the attorneys, if they'd have gotten that judgment, they were in agreement that then I could file some UCC1s on them.
Okay.
But I'm not going to
Okay.
file any UCC1s on them until they prejudice my interest.
Okay, so
Until
you
they
didn't
until they steal my money. Right? Because until the case was over, I really had no knowledge whether or not they were going to dishonor or prejudice my interest. There's no prejudice on my security interest until there's a judgment against my collateral.
Yeah, because see, the judgment's fraud because they already been paid. And on the private agreement that
The
Brandon
judgment would be
had,
fraud.
he basically said, you've got your $5 million, but if you come and don't recognize that because of my subrogated interest, then I've got a claim on you for $5 million because you got another judgment on me for $5 million, which is separate from that original bill. I paid you on the original bill. It's gone, but now you've damaged me with a new judgment. Then the new judgment is supposedly for what you already paid. So now you owe me back the $5 million.
So that's the notice that you put in your
That was
document.
on the agreement on the private side, and the judge knew about that.
right.
So if the judge would have issued a judgment, then he's got a damage. Then he can file a UCC1
Okay.
against them as debtors based on the fact that they created a new liability against them that they were already paid on the last one.
And they agreed that everything
So
that
then-
they owned was collateral on that.
Right. So then when you file that UCC1, you're just going to reference the information at the bottom. You're not going to
Reference what information?
the
The UCC1 was a security agreement, but it was between Brandon and
He's just gonna
Brandon
reference it
Private
and box
Trust,
eight, all that stuff.
Brandon Public Trust, Brother Public Trust, Corporate Public Trust. So that was a contract in-house. It had nothing to do with these people.
right.
That's the
right.
basis of the UCC1
Yeah, my
filing.
UCC1 really had nothing to do with those attorneys. My UCC1 had to do with all the defendants'
The people were
interests that I
trusting
had.
him to give
They
them a
had
remedy.
basically pledged all their assets to me. And because I was putting up $5 million because of their debt, I also had a $5 million interest on top of that.
Okay.
So really, because I put up the money, the private trust, I had a $5 million interest in all of the defendant's property, including the case number itself, because they were named as parties on the case. What does that mean? It means they've got an interest in that case, what's a case? It's an account. Any parties named on the account have an interest in the account. So any interest the defendants had in that account, I got. I have a $5 million interest in that account. So the case number itself was listed as part of the collateral.
On the UCC1.
But Brandon did not bring a liability on anyone at the time that the case was still being heard, because he'd already set off. They wanted 666K, and he gave them 5M. So where the hell is their claim? They ought to disappear. Oh, well, we're going to test that theory. We're going to see if Brandon is truly a creditor or a debtor. And so we're just going to put out all these carrots, and if he bites on a public carrot, it disqualifies his private trust set-off. Then all of his filings will be stricken from the record. The judge will come down with a public judgment. All of the defendants are going to get, and then after that, the plaintiff will get their funding out of the public side judgment. And the private bond will just go into the deep well. It's gone. It's disqualified as the remedy. So again, 2 years of testing to see if the private guy is going to stay over there on the private side.
I have a question with your the time of the process. So you said that you was able to send this the paperwork into the judge's chambers.
The notary sent it in.
The notarized paperwork to
No. The notary made presentment of their record to the judge.
To the judge within 22 days, you say?
That's about how long it took for my process to complete.
Okay. How were you able to find out what judge would be hearing your case?
Well, he was named.
The case was already
right
filed.
when the case was filed. He was named as the judge on the case.
Okay.
So the private
it's
process...
it's not like a traffic citation where you may not know the judge. This is a major case.
They'd already been served a summons and a complaint.
Okay.
So they didn't start their private remedy until the public had cognizance that there was going to be some proceeding going on.
Yeah, because I didn't have knowledge of it until there was a public proceeding going on.
And when you're submitting those...
Wait, hold on.
And when you're submitting those documents to the judge, how do you address the envelope to ensure that the judge...
The notary was submitting, but you prepare the envelope.
Yeah.
And so it goes to the Honorable so-and-so, maybe care of his private secretary, and then the address in the courthouse.
And that's how I addressed it, but the judge who attended the class last week, he told us all kinds of other things you could put on the envelope to ensure it gets there. He said, he includes something about in camera, and I don't remember the exact verbiage right now. I haven't even uploaded the audio from those sessions yet, so I haven't even had a chance to listen to the class. But what I would recommend is that when you get a chance, download the audio from the April 2010 Living Temple session. And you'll hear, and he went way beyond just discussing public commerce and private commerce. He went into things about amicus curiae, appearing in the court as a third party with an interest, and all kinds of other things. He had all kinds of great things to bring to that session, and I'm so grateful that he appeared there and gave us the information that he did. Because up until then, I had no idea why my court case worked. I didn't know why it worked. You know what I mean? I was just like, cool, dismiss with prejudice, right on. And I never had to show up.
That literally happens to us a lot. We luck into something, and years go by, and we go, wow, that worked, but we don't know why. And then 1 year, 5 years, 10 years later, we learn some process, and we go, that's how that thing worked.
So we can handle all of our private matters without actually going to court directly with the judge?
Absolutely.
I went to court.
Well,
on the private side.
Yeah.
Right.
Was he there personally?
Right.
He was there by paperwork.
And why would I have to be there personally? I wasn't a party to the case. Right?
Right.
My collateral was but I had instructed the collateral they better not appear and prejudice my interest.
See, the public Brandon Adams could only go in as a debtor. And in what I showed you yesterday, that was box 6B. That's the defendant, the debtor, the straw man. We talked about box 6A, which is an authorized representative. That's a title of nobility saying, I'm an ambassador for box 2. Now, box 2 can't go there because if box 2, the private trust, shows up, you've just done a public appearance and you're outside of the protection of your nation and your country, which means you're subject to the laws now of the public rather than the laws of the private where you're from. As an American, would I voluntarily appear in a court in Paris, France, if their laws were so different from the protection I'm coming from that merely by going to that court, I'm going to be subject to their laws and not mine? So what Brandon, the private trust, needs to do is you need to settle the matter as the laws of your country require you to do so, because you're subject to the laws of the nation you subscribe to. We talked about the fact that under the Second, 13th Article and Amendment, these titles of nobility in the democracy cannot appear in the nation of the republic, and they will not. If it's treason for them to do that, is it not treason for us operating in the republic to do a general appearance in the democracy and subject ourselves to the voluntary loss of all of our titles and rights? I mean, this just makes common sense now that you're become aware of it. And the reason we did that map is to graphically show you what's happening when you go through certain process.
And that example that Jack just used of, okay, something's happening in France, right? And I settle it in the United States. How do I get record of the settlement into that court in France?
Letter rogatory.
Letter rogatory.
You have a question over here, been holding up.
Let me make sure I understand what you just said, if I'm listening correctly, is that if we file a UCC1 in the correct manner, we can also take care of mortgages and things
No. Hold on.
Okay.
The UCC1 had nothing to do with my remedy.
It's just a notice.
I just had that as a public record that was included as part of my process. The UCC1 is not substance. Okay. UCC1 is form.
Okay, but the important part of UCC1, we talked about this yesterday. What was the critical aspect of a UCC1? It shows that the presumption that Gordon is Gordon. What do you mean you're a secured party creditor? You're the defendant. The court wants to see Gordon as 6B. Gordon is trying to explain, I'm 2. The court's going, you're 2? Where the hell did 2 come from? Well, it's this far distant country. We can't see that country. We have no idea what's going on there. You are here. You are Gordon. You are 6B. Well, if you do a proper UCC1 filing, the secured party creditor is box 2. The debtor is box 6B. Is that a public record, that filing? Can it be brought under seal from the Secretary of State? Yes. So it qualifies as an exception to the hearsay, and it is includable as evidence in a court case. Now, the UCC1 did not give Brandon a remedy, but it was included in his file. What importance did it have in his file, and what did it do when the judge's eyes in terms of giving Brandon, the private trust in box 2, a remedy? It showed that there's 2 Brandons. It showed that there was a box 2 Brandon, and it showed that there was a box 6B Brandon. In the judge's mind, he's going, well, who's the defendant in the case? Oh, the defendant in the case is box 6B, public trust Brandon. Well, then, who the hell is sending private process in through the notary into chambers because I will not allow the public trust, Brandon 6B, to be communicating with a judge in chambers. Because if he's sending something into chambers, he is the defendant debtor. And under our public rules of procedure, he's got an attorney. Oh, he doesn't have an attorney. Well, that's okay. He's still a debtor. He can't communicate with me. He's a defendant. He has to approach me through the public trial. So the judge would disqualify this document coming in from Brandon Public Trust 6B. But since he has a document that's includable under the rules of evidence that the judge has to take cognizance of, he's going, oh, I get it. It's just a confusion into names. There's two Brandons. And this is the Brandon creditor. He can come in through chambers. But the Brandon debtor can't come in through chambers. So the document was absolutely includable, but the only part it plays in the settlement is, does the Brandon that sent the documentation through his notary have the capacity to approach me in chambers as a creditor? Because there's another Brandon and he's a debtor. Oh, okay, he's been recognized as a separate entity on the records of the Secretary of State. That Brandon can come in. You see what happened?
The UCC1 is the one that you filed actually.
You're not. But I also rebutted that presumption in my letter rogatory. Remember the first line of my letter rogatory was, I have been contacted by Brandon Alexander Adams, hereinafter principal, from outside the United States. Does 6B exist outside the United States?
No. It's in. Okay. So it's it's the Brandon Adams, not the other Brandon Adams.
You actually referenced it in your cover letter.
A jurisdictional statement.
No. I did have the UCC1 in the records that went into the court, but by using that particular statement in the letter rogatory, I'm basically saying, hey, this is from the creditor.
Second witness. Right. 1, the UCC. 2, the instructions in the letter rogatory.
Yeah, I'll include that letter.
Don't you hate it when people's faces light up and they get this big smile? Don't you hate that?
They ain't going to come to any more seminars
No.
if they know everything. So
They
you
know
guys better
everything.
start getting more a little confusing, because if they get all this, you ain't going to have any more people to
I
come to
will
your seminars.
confuse them this afternoon. No
What
worry.
time is it? We got lunch break, Brandon?
Hey, Brandon, whatever happened to the CEO? Or do you care?
The CEO of
On your corporate.
Actually, he got off the hook too.
Because Brandon paid
because
his
I
debt.
paid his debt. Even though he wasn't my collateral. I paid his debt.
They didn't bring a judgment against any of the parties because one of the parties paid the whole thing.
But he did waste a lot of money on an attorney for 2 years.
And you know the adage, God will get him in the end?
Okay, what happened to your guy that hired the attorney?
He actually, he went back into the military. He was like, I can't be prosecuted if I'm in the military. He had already retired from the military, and he went back into the military to avoid any judgments against him. So he'll eventually get back out.
He's hiding in the closet.
So say my brother goes and damages some public property or something, and I counsel him, I give him a lecture about it. He's scared to death, and there's a case filed against him by the state or whatever. Now first off, from the time that case gets filed, now is it possible, the first part, that I say, okay, I want to take a paramount security interest in him, and I put notice on the UCC, and I file that, and I guess I can just file that into the court documents with the case number or whatever, just to say.
Whoa, public or private? How are you helping him?
Well, where I'm going with this is the reason why I'm filing that is just because if I'm saying I'm gonna stand in and take care of this, I just want it known, that public document, that I do have a paramount security interest. Because
UCC may have made a general public appearance. You can protect him as brother's keeper, but you better keep your process on
Oh,
the private side.
yeah, the process is private. I'm just saying.
You can give notice to the public.
That's what I mean, giving notice.
Right, but your notice to the public was just the filing of the UCC-1.
Okay.
You don't come in on this side of the case.
With the UCC-1.
Because in reality, you're not a party. Why would you be over here?
Well, what I'm asking is, because say if I want to send a letter to the court, I mean, though it is public, it's public already because it's public once it's filed. But if I wanted to send a letter to the court that basically says, hey, I'm going to settle this on his behalf.
Okay, hang on a second. You're confusing something and not separating. Notice to the public gives notice that you've got an interest, but your interest could be public or private. If it's public, they've got control over it.
Mm-hmm.
So notice is one thing, but where the security interest lies is another. You need to keep the security interest, the titles, on the private side. So you can go to your brother and say, hey man, you've got an interest herein. Let me on the private side agree to buy into your interest, so I've got standing to stand in as a creditor like Brandon, the private trust, did, to help Brandon, the public trust, and all the other public trusts. Now, your brother, chances are, is going to be only a public trust. He is a private trustee, but he ain't got a clue how to do that, and he isn't going to do it because it would take too much time, effort, or he doesn't believe, whatever it is. But if you're going to step in, you could step in on the public side. Why would you do that? You're a debtor. You can't win. You're going to get his punishment.
Well, I guess what I'm asking is, if say I was going to say it's something, and it's something I know that can be set off.
Okay.
Now, the reason why I'm asking this is because if he gets this summons, he has to go to court on whatever date.
Let's say he broke a window in a neighbor's house and it's going to cost $500. You could buy into the transaction in some way, come in on the public side, take $500 of Federal Reserve notes out of your billfold, pay the other guy to go away. The state's going to say, well, that's the civil side. We're here criminally. Somebody's got to go to jail or whatever. And that would be another issue. But you could settle it on the public side. It's just contract law. But what we're trying to show you is ultimately our power is bringing life back to the republic.
Okay.
Because in 2 years from now, there's going to probably be even more serious problems in the public. If we don't have this 2-year opportunity to learn how to invigorate the republic and get it back, and there's not going to be a lot of people that are going to do that. We got to get enough people under the theory of Sodom and Gomorrah. Lord, if there's 10 in Sodom and Gomorrah in a population of 50,000, are you going to nuke it? Nope, not even if there's 10 would I nuke it. So how many people do we have to have go back to the republic? Not a lot. But if we don't get some, it's going down.
Well, and the other question was, from the time you put notice out there of your paramount security interest in the other in your brothers in the other parties,
public trustee,
the public trusts, is there an amount? Is that immediately as soon as you put notice out there, or is there some type of maturing time or anything with that effect?
If I wanted to liquidate on him, there'd be a 90-day maturing period. But I'm not. My intention wasn't to liquidate my brothers. My intention was. And the thing is, the greatest
instantaneous.
The thing is,
you go file it with the state, get a certified copy.
We've just given you.
Go up to Norwalk.
We've just given you the how of I know how to operate in private. I know how to do administrative processes. My brother does not. How can I help? We've just given you the how-to. But what does it require of your brother? No. Faith and trust. Because in reality, if I just walked up to someone and said, hey, I want you to grant me a $5 million interest in all your property, and I want you to sign the security agreement where basically I control everything. You see? That requires some trust, doesn't it? So my brother, my corporation,
had trust.
And they had trust. They had faith.
Okay, look at it this way. Didn't the guy's wife at the time They went into the agreement. Didn't she have faith in her husband?
We're talking about the bifurcated divorce.
Agreement. Okay, so now the husband doesn't have this security agreement to destroy his wife. Under the scripture, didn't the husband and wife become one when they were married? And under the marriage vows, under God, the state don't give a hoot, but under God, wasn't it in health and in good times, in bad times? And so the wife is putting all the faith commercially in the husband that the scripture by the union and contract under God required them to do. Now, the wife decides, I'm going to run off with this other dude and become irresponsible, and I don't care. Now, the husband still have this contract. Now, does the husband have the right and the ability to cut the wife loose if he wants to? Absolutely. The wife's gone, and I said to my friend, I said, well, what's your intentions here? He said she is irresponsible. She thinks she knows. She ran away with the guy. It lasted 6 months, and they're separated, and now she's a druggie, and she's everywhere. I mean, is this responsibility? No. Has he still got the security interest? You bet. I said, what are you going to do with it? He said, I'm going to protect her. That's my job. Well, she's no longer married to you. Well, she needs protection. I don't know if she's ever going to come back to her senses. I said, well, would you ever consider giving that up? He said, absolutely. If she finds another guy and wants to get married and she's responsible, I would cut that loose in a heartbeat and assign that to her new husband. So what is Brandon saying? My brother, everybody gave me this security interest. So Brandon's going, I just paid $5 million for you bastards. Are you going to pay me back? No, he don't want paid back. He's protecting his brother in corporation. After it's done, could he assign that interest back to his brother in the corporation? Yeah, if he wants to. What if he doesn't? That means if his brother gets into some other problem, what just happened? Brandon's got to solve it for him because he's responsible.
Which, interestingly enough, just came up.
And this is why Garrett's in indentured servitude doing the cameras.
So he's behind the camera with the headphones on. He's paying me back.
You see, you don't file these security agreements to enslave your brother. You file them in order to protect your brother. You're never going to charge him. You don't charge your brother. You love your brother. Notice that only Brandon, the private trust, was involved in the settlement. But when one creditor steps in, what does he do in behalf of all the debtors, even the bastards that caused the problem? They're all set free because of the action of the creditor. When the Messiah died on the cross, who was set free? Everyone, even the bastards.
Especially the bastards. Okay, we're coming up on lunch. One more question. We got to cut.
Brandon, is there any way you can go into after lunch how you'd use the private side and the public side to handle your mortgage?
Well, in California, we don't have a judicial system.
Okay. We'll talk about
We're going to get into a money issue sometime, and we'll show you.
I imagine we should probably do a session on handling mortgage and accounts and what I call the 3 necessities of handling a situation like that: handling the account, handling the title,
right,
and handling possession.
If you could do that in order and how you'd that'd be great.
We'll start it on the money issue and show you how the accounts get.
All right, so pay attention closely. Go ahead and cut. We're going